Assalamualaikum and good afternoon, ladies and gentlemen. This is my honor and privilege to be a part of the PACE, and I'd like to thank to all the board members and the members of this organization to organize this event. And as I've been asked to give some point or some lecture regarding the how to make a will, and this is very important things, and so I'll try my best to summarize it. Now we have some misconceptions regarding the will. People think that if I die for any reasons, so what's going to happen to my property? Are the state going to take everything, and my children, my wife, are they going to be deprived from my estates and assets? That is the misconception we have. Actually, that is not going to happen. Only thing is going to happen that there will be cumbersome to transfer your asset to your spouse or your children. No. And that's why we have to make a will. We have to make will in the sense that there are few components I can tell you. Now, if you have a house, most of the people who have the house. Now, if you have a house and a house is in your name only, then if you die, then what is going to happen? Then your wife is not on the title. If your wife is not on the title because there's some problem of his or her credit, that's why she was not in at the time we bought the house. Okay, now, if that's the case, then you have to bring an application to the court. It's called a certificate of appointment of estate trustee, and that takes 6 weeks to 8 weeks, maybe sometime more. And same time you have to pay the probate fee. So in order to avoid that, what we do is tell our client, now if we have a house in both the name, husband and wife both the name, we can register your house as a joint tenancy. If we do that, then if husband dies, then we need your husband's death certificate. Then we can transfer the property to your wife without any hassles, because she is there on the title. And we call survivorship applications. That is very easy, and it is very much cost effective. Now, if is not there, if his wife's name is not there for some reasons, then you have to go through a court process. So in order to do that, and then you have to bring an application to the court and say she will say my husband died without any will. So then we have to bring an application, and then based on application, then we get the certificate. Then the lawyer will take care from there, and he or she can transfer the property to his wife. Now let me finish it. Then we will entertain all the questions. Good. Now, sometimes what happens, you have a house, also you have a cottage, you have other things, assets or condominium. We call it investment property. That's on the husband's name. And as long as husband is alive, then we can transfer, or sell, no problem. If husband is dead, then we have to the same process we have to go through the court. Now, also there is a question of the capital gain. Now, if it is a principal resident, then there is no capital gain. But if it's not, if it is investment property, then there is a capital gain will be considered, and you have to pay. Now, in order to make a will, you need very simple thing. You need a list of your assets. You need whatever you have a bank account, and then you have a desire. What do you do? If you die, then who gets what? And you have children, you have grandchildren, or whether you want to give everything to your wife or not. And you need 2 executors, we call trustee. One is going to be a little bit older, and one going to be a little bit younger. So 2 executors means if one executor die, then we can get another executors. Okay. Also, we need 2 witnesses, that their name and address and their ID number, driver license number we need, so that we can trace him when the dependent dies. So those are things there, and will doesn't need to be registered. So once we prepare the will, and we give you the original back to the applicant or the party, and they will keep it. and if he or she dies, then the lawyer will take care from there. Now, you can change the will anytime. Once you make a will now and 6 months later, and you can change it. That's the whole thing about the will. Now, you need for the tax component, you should be talking to a tax advisor, and he will be giving you guidance how to avoid taxes in terms of when you die. Because there are RSP, RESP, there are some other benefits there. Also, same time, if there is a life insurance, you always have a beneficiaries. Beneficiary automatically gets it. If a bank, if a joint account, then there's no problem. But you have a safety box, it has a one name, who is authorized to open it. Then his spouse cannot open it because there's only one man has the access to it. Then you have to go through a court. So we usually convince to the client it's better to have a will just in case, and so the husband can make a one will for his wife can make a one will for the husband. So we don't know who is going to go first. Someone has to go anyway, and it's a matter of time. So that's all about the will. Now, and other thing I will say that how do you divide your content of the house? What are the items you have in the house, who gets what? Those are things you can list it, and then you can take from there. And if it's less than $1,000, there is no tax consequence on it. If you own a house in Florida or some other places, and when you sell that house, that there is tax consequence is there. But in Canada, we don't have. Now, sometimes the people will ask the question whether the witness or executor has to be Canadian or he has to be living in Canada. Because as long as they are living in the Commonwealth country, then we will find. But how he is going to come to here? Definitely you need a visitor visa or whatever. So it's better to have somebody who is living in the province of Ontario, so then you can have easy access. And he or she does not have to go to the court. He comes to the lawyer's office with the will, and we make the applications and file to the court, and we get the certificate and we take from there. That's all about the things about the will. Now, if you have any questions, now Gio. Now any question comes, please.
Okay, so I think you already asked all my questions. So it looks like we have to have a separate will for wife and husband.
Right.
It's not one will covers both, right? So the survivorship certificate that you mentioned that you have to have, does one covers both, or you have to?
No. Okay. You are finished?
Yeah.
Now, what is survivorship certificate? That if we have a will, if we don't have a will, suppose you don't have a will, the house is joint, husband or both the name down there, we call joint tenancy or tenancy. Yeah. So if you have a joint tenant as a title, I just need this death certificate, and bring to the lawyer's office, and lawyer will prepare a document. It's called application for survivorship certificate. So based on the application, we just transfer because it was husband and wife's name. Remember that. We just husband died, so we're just going to transfer to the wife. So that's what we're going to do through the lawyer's office. So and the cost is very much minimal. And we don't have to we don't have to go to the court for that, because it is joint tenant. But it is tenants in common, because they have share that one has a 1%, one has a 99% share. Then it would be the problem. Then we have to find out how we can resolve it.
So it will work both ways, right? If wife dies, then the wife's portion of the ownership will transfer to
husband. If they are on as a joint tenant, suppose you have a house, have a joint tenant, is a principal resident, doesn't have any capital gain, so that can be waived. There is no capital gain. But you have a cottage. You think in the cottage is only my name, husband's name. Husband dies, then I can transfer it. So then I have to go through the court and get a certificate. Then there is a capital gain on the cottage. Then we'll see how much you bought the cottage, how much cottage value right now, and how much money you have spent to upgrade the cottage. Based on the net amount, you pay the capital gain. But
will not tell Bobby that you say that.
okay, go ahead. You have questions, yeah.
So I have actually several questions. Sorry for that. First question is, what is probate, and when do we need that?
Probate is a government fee. Government fee, yeah. And government fee when you transfer the property. So when you are making application to the court, it's called certificate of appointment of estate trustee. Then the first $50,000 is multiplied by 0.5%, and remaining will be 1.5%. Now, if you have a house worth of $800,000, you have a mortgage of $600,000. Net value is $200,000, right? Multiplied by 1.5%. Whatever comes, you have to pay the money to the court in order to get that certificate. We call probate fee. Now, we don't have any state fee, unlikely in USA has a state fee.
So if we have a will, we have to go through this probate process.
Yes, because the government needs the money.
Okay. So if we don't have a probate like a will, then what will happen?
No. Question is that you have to pay the probate anyway.
Okay.
But when you don't have any will, even if you have a will, when you have a will, you have to go to the court and ask for the certificate. But at that time they need that. Only the will is going to give you the direction. Look, if I die, something goes my wife, something goes my children, all these things. Now, at the same time, if a husband and wife has a 50% ownership each. Now, husband say, you know what, I don't want that if I die, that my 50% I don't want to give my wife. It is statutory right that I have 50%. So then, because I don't want that husband, my wife, take everything, I want to give them my 50%. $1 million asset goes to my children, my 2 children. You can do that. But the children, and the will, yeah, we can do that. That can be done.
So next question is generally how much it costs to make a will?
Okay, the simple will, I'm not going to give you dollar figure. Simple will is simple will is made takes over 2 hours. So 2 hours, if I say a minimum is 150, so you're talking about $300 plus all the disbursement. A single will. If will is more complicated, then your money goes up, fee goes up. Now, I know that one will I have made, and one gentleman, and every 7 days he comes and say, Mr. Sultan, I want to change this, change that. Last time I called that up, and he said, I want to make my new will. I mean, well, and he said that I want to give everything to, what's your name, honey? So my name is so-and-so. How old is she? She is 45 years old, and I am 95. So I said, Robert, I'm sorry, I cannot, or John Doe, I cannot do this will, because it seems to me there is some influence going on. Because you are 95, you have more than $1 million worth of asset. I am giving someone who is giving you PSW, something like that, a personal support worker, is helping him, all those things, and I'm out of it. I mean, I cannot do that because we are changing will, which I have done in the past several times. Now we are changing this will. So that is the other things. So and I make sure that's when you have a good state of mind, you can do that. Now, besides the will, you need 2 things. So you have a car accident, you didn't die. You have a will, you have $1 million asset. You didn't die, so I cannot do anything with the will because you didn't die. So in that case, then we have to prepare is called a power of attorney for property, power of attorney for the personal care. On the power of attorney for the property, you will say, you know, I don't want to go through all the hassles. I want to transfer right now that I have a power of attorney. I can transfer the property to my will, to my wife. You don't have any will, but you have a will, but you didn't die yet. So without going through court, paying the probate fee, I can simply transfer to your wife because you're still alive.
In any case, for this, if both of them die in a car accident or something like that, what is the right of the children to claim the property?
Okay.
Number 1. And number 2, what is the situation when the children are minor?
Okay. So if the children are minor, then we have to find out who will be going to be children in given state, children rape. So because you don't have any will, nothing. So at that time the children's very close relatives, maybe children's uncle or aunt will come to the lawyer and say, look, my brother died, wife also died. The children are minor. I only want to be the children in given state than the social welfare agency. Okay, so then we have to bring an application to the court, ask for that, first one. Second one, then once the court appoint that guardian to be the minor, both are the minors, so they represent the minor, then the guardian, then we have to bring an application to the court, ask the court that the couple died without having living in a will, so that we will get a certificate of called a state trustee, appointment of a state trustee without a will, and on that will then we're going to ask for the whatever property is down there is going to be how we're going to put it in. So then the state is going to say, okay, now until the day became 18 or 22, so we're going to put this the property on the care of the trustees. He's going to hold it, or he's going to get the benefit from there and put the money in the trust, and when the children become an adult or become 18 or 21, then it's going to be divided. So it will be more cumbersome, because even though you have to have two applications, one for the guardianships and another for the certificate.
So the supplementary question is it advisable that the parents have a will that in case both of them die simultaneously together, that the property goes to the children?
Yes, and in that case, that if the children is minor, then you should have somebody else who is the children guardian. So that guardian. And I always ask most of my clients, don't put 18 years, put a 21 or 22. Why not 18 years? Because I have a client, just she became 18 and say, Mr. Sultan, you have to sign this document, and so I had $100,000, my dad left me, I want to take this money. And I don't want to go to the, I don't want to go to the school anymore. So my dad left $100,000. And I have a boyfriend, and I was going to buy a new car and enjoy the life. So from that day, I decided, that if the will or the document says that until she became 22, when 18 is the high school, 22 means coming from the graduation, right? That will be right age to understand the better than the 18. So that time she may need more money and need more money and spend money better way than buy a new car with a boyfriend. So that's why I usually say, put 21 and 22. Good. Yes.
Same? No, this question was a supplementary question.
Yeah.
If there is a mortgage on that property where the parents are dying, so who's responsible?
The mortgage, okay. So because the property is going to hold by state trustee or executor. So we get a certificate and giving the gentleman who is going to look after the children, and he will act as a trustee or an executor or an executrix if he's a woman. Then that gentleman is going to decide what the best interest for the children. Are we going to keep this house, or continue with the renting, or sell it, put the money in the trust? That's going to happen.
And the social welfare will be consultation, right?
No, because we are going to bring application. They will say, social welfare agency will say, no, that uncle is not a good uncle. Because he has so many issues. We want to be part of the, we will take care of the minor children. So it's better to have somebody who is willing to do it. Usually we go for a maternal side than the paternal side, maybe the culture we grew up with. And if that is the case, it's fine. And if you feel someone who will really look after my children if I die, and then you can name that. Two people name. If he dies, then this other one. Good.
I have a question. If the property belongs to one person and he dies, then what is the procedure?
Is the husband or wife? Is the husband or wife?
Children.
Yeah.
But property belongs to one person, then.
If the property belongs to only the husband's name, some reasons, wife is not there. Wife is the principal resident. They're living in the house.
Yes.
The wife is already in. The wife has a 50% share of the house. The wife has to bring an application to the court, and that my husband died without a will, and we get a certificate, and we can transfer to the wife.
The procedure.
Usually we say 4 to 8 weeks. sometimes it takes more than that. You know, 4 to 8 weeks.
4 to 8.
That means 2 months. Sometimes it takes 5 to 6 months because there's so many applications comes to the court. Yes.
In which cases the survival spouse supposed to pay to the court any
Probate fees?
Yeah. No. The probate fee comes this way. The husband and wife, if there is no will, suppose there is no will, the husband dies. So wife going to bring an application to the court and say that my husband died without any will. Then at that time the lawyer is going to figure out how much the worth of the house, okay, what is the mortgage, what is the net of the house price, and based on that they multiply 1.5%. And you pay the money to the court in order to get the certificate. Once they get the certificate, then the lawyer has the power to transfer to the wife's name.
I have a question. What happens if you have a property in Bangladesh? If I make a will here, will it cover that?
Of course, we're not going to cover that because the jurisdiction of law is not going to cover that. No. So,
like for example,
in Bangladesh, there is no will. Bangladesh, they guided by Muslim law, so there is no will. There is a system called gift or heva. So, lawyer does not sign on the will. We sign then it's called a affidavit of the will. That the two is signed and you also signed. So, and most of the lawyer is not going to sign any affidavit of the of the execution of the will. We don't sign that because we don't know who did that under what circumstances. So that is very hard to the judge to be convinced. Yeah. So that's why has to do that. Okay. And you also you have questions? No.
No, I mean the idea to have something written here. So like both parents die and each doesn't know what kind of property their parents may have in Bangladesh. If they have something written here, down the road, they can prove at least.
Yes.
If they go through the legal process.
Yes, definitely. And sometimes if you write down the name of the, at least one lawyer, he or she would prefer to go or talk to them, so that they would know that okay, fine, my parents died. I heard that my parents had lost the property, so how we can get that? Well, thank you.
Thank you very much. Well, you have the last question and then we'll... Okay.
So for regular or normal will, you don't have to go for trustee or executors. Right? For regular one, like for family level will, you only need the witnesses, not the trustee or executor. Am I right?
No, you're wrong. No, on the will we put down the name of the executor. We need two.
What the executors would be?
Executor, because when you die, someone has to execute the will. So the executor, or we call executor, or we call trustee.
Okay.
So executor trustee, he will come to me and say, Mr. Sultan, my brother died and he left his wife giving me this thing, he left this thing for me. So then I take a look and say, okay, fine, you are named in the will as the executor. Okay, fine. So an executor only do, then bring to me to the lawyer, and then lawyer will get the certificate.
And you need two executors?
We need two executors. If one executor dies, then we can get a hold of another one.
Okay, and then two witnesses.
Two witnesses, yeah. So the two witnesses.
Friend, they can be relatives.
Anyone, yeah,
So,
yeah. But he or she has to be informed that he is going to be a witness.
All right, and also, do you also need to include the vehicles and cars?
Anything, yeah.
That should be also be included.
Yeah, included.
And locker as well.
Yeah, locker, yeah, locker and locker, yeah.
If you're not under two names, it has to be under two names, or you have to mention.
Right. Good.
Thank you very much.
Thank you very much for coming down, and we have to thank Mak Sultan Bhai for giving his valuable time and valuable information for us, for spending his valuable time. Thank you very much.
Thank you. You're most welcome.